I wouldn't miss it. This is the first voyage of this subcommittee under the chairmanship of Amy Klobuchar. We certainly know Senator Klobuchar knows antitrust. In fact, she's written a book. It's called Antitrust: Taking on Monopoly Power from the Gilded Age to the Digital Age, coming soon to a bookstore near you. And I'm told it's only 624 pages long. So it's just in time to become a runaway bestseller summer vacation beach read. I'm sure it will be a success.
You may be surprised. There are cartoons.
I'm looking forward to the pictures.
That's one night's reading for Senator Lee.
Yes. And let me just tell you, 15 years ago, I walked into this room and sat down at that chair, and Senator Specter had a subcommittee hearing on a topic I'd never heard of before. It was called the interchange fee, the swipe fee. I didn't know what they were talking about. And the retailers all lined up at the table just like yours and explained what was going on here. They said that these fees, swipe fees, were being charged by Visa, MasterCard, and the other credit card companies to all of the merchants and retailers who were using them for card transactions. It turned out they were not negotiated. They were mandated. Visa and MasterCard said, this is what you will pay for each transaction at your restaurant or shop. And you have no bargaining power whatsoever. If you don't want to pay it, don't use Visa or MasterCard. See how long you last. Those fees were far in excess of any reasonable measure of cost and far higher than they would have been charged in a competitive market. But Visa and MasterCard still are so dominant in the payments market that merchants couldn't stay in business without using their cards. Last year, American retailers and merchants paid out a staggering $62.5 billion in swipe fees imposed by Visa and MasterCard. And the fees, incidentally, they announced, are going up again next month, just in time for your little restaurant that somehow managed to survive and reopen in a pandemic to go into business and have your credit card company say, now you're going to pay us even more. All those costs are ultimately borne by consumers across America. And I have seen, by and large, the power of Visa and MasterCard throughout this whole process. I introduced an amendment, affectionately known as the Durbin Amendment, which is either famous or infamous, depending on your portfolio. But it took $8 billion out of swipe fees a year from Wall Street, and they didn't forget. They're waiting for an opportunity to get even again. Where is the policing authority to stop this duopoly from doing this to every merchant and retailer in America? I don't see it. My question gets down to something even more basic. It was 20 years ago, I believe, I had lunch with Judge Posner in Chicago, an interesting man, and we talked about a number of things. He had been appointed to a case involving Microsoft at the time, and he is a very smart man. He's since retired from the bench. But he's viewed as a very smart man, controversial in some circles. And he said to me, I find it very difficult to understand the complexity of the issues in this case. I cannot imagine a jury of just ordinary Americans even grasping what we are talking about in these cases. So let me ask you, when it comes to the ultimate arbiter, a jury, a court, are we talking about issues that are so complex in their nature that they're likely to be settled out of desperation because there's no place to go? Mr. Lynn?
I mean, that's an excellent question. And it actually gets at one of the points that I think is really important for us to understand about anti-monopoly law, which is that structure is important. When you have a corporation that is extremely complicated, that is extremely far-reaching, that is engaged in many businesses all at once, I mean, say Google, it becomes impossible for anybody. I mean, not even just a juror. There's no government agency that could ever understand what's going on inside of Google. And then you don't want to build a government that's big enough to understand what's going on inside of Google. That's why traditionally in the United States, we focused on bright line rules, bright line separations. If you're distributing information, you don't develop information. If you're selling books, you don't publish books. This is the way to make antitrust usable by everybody, to make it understandable by every juror in the United States, is you get out the broad axe and you cut things along lines so that everyone can understand what they do and what they should not do.
Let me ask Mr. Rybnicek your point of view on this.
Yeah, I think there's no doubt. Antitrust is a fact-intensive exercise that requires some amount of work. I think the judiciary is very well placed to address these issues. They are maybe not all experts in economics, or even most of them, but they are experts in interpreting documents and
Excuse me, educate me. Is there a special court or a special area of courts that enjoy this expertise? Because I've had a hand in picking a lot of federal judges, and I don't know that any of them ever stood up and said, I'm just the person you want to go to in a complex and antitrust case. I have the background.
No, I think the point that I was making is that they are experts in interpreting evidence, whether it be documents, witness testimony. That is what they're asked to do in these cases. They're no doubt fact intensive, and they do it, frankly, better than some of the agencies do at times. Right? The FTC has an internal court, and so we can compare the records. And the agency has a certain win rate, and then those cases are appealed to the Federal Court of Appeals. And more often, the Federal Court of Appeals overturns the FTC's internal decisions more often than it does the district court's decisions. I think that is informative.
Mr. Slover, would you comment on this?
I think there are inherent complexities which challenge any court to come to grips with. I think that's one of the advantages of having the Federal Trade Commission as a separate organization with the bipartisan leadership and its own internal processes, so that some of these issues can come better to light for education within the commission and also education with the public. I think there are inherently challenging cases, and one of the challenges is to try to simplify the issues in a way that uses the economics that need to be used to give rigor to the analysis without obscuring the essential truth of what's going on.
Is it time for Ms. Baker to respond?
In terms of courts having authority, they have clear authority under Article 3, Section 2. I think it makes sense that we can't say that this area of law is too complicated. When they first have the constitutional authority, and what are we going to do with the administrative law? There are other areas of law that are complex. This isn't unique in that way.
Thank you. Thank you. Madam
Okay,
Chair.
thank you very much, Mr. Chairman.